Good morning and welcome everybody to Fact Friday. You'll see that I'm joined by Alexandra Gordon. Alex, good morning. It's good to have you back with us.
Morning, Michael.
So this week we are looking at the provisions for children within your wills. If you pass away without leaving a will, then any money left to your children would automatically pass to them at the age of 18. Today we are looking at the different types of structures you can include within your will to protect your children further down the line. Alex, we have two questions today. The first question is, if I leave money to my children, say for example at the age of 25, do they have to wait until their 25th birthday to receive any inheritance?
No, so there's provisions to allow the trustees to advance either capital or income out to the children before they reach the age stipulated in the will.
Excellent, thank you. And the second question we have, Alex, is, are all trusts for children taxed the same for inheritance tax?
No, so there are different ways in which you can leave monies in your will for your children, and there are different inheritance tax consequences for each of those. As a general rule, if you set up a trust in your will, it will fall within what's called the relevant property regime. Now, this means that there will be extra inheritance tax charges for the duration of the trust, and these will be every 10 years and every time money is paid out of the trust. Now, these are a maximum of 6% on any monies in the trust over £325,000. The most common relevant property regime trust is the discretionary trust, but it will also include trusts where you leave, say, everything to your children at the age of 30. Now, there are some exceptions from this. So if you take a look at the photos, the first option is what's called a bereaved minors trust. So this means that everything must be left to your children at the age of 18. If this is the case, then the trust does not fall within the relevant property regime. The only downside of this is that it must be set up by parents. It can't be set up by grandparents. The second option is called an 18 to 25 trust. So with this trust, your children must have inherited their share of your estate by the age of 25. Now, the relevant property regime doesn't apply in this instance until the child reaches the age of 18. So between the ages of 18 and 25, that is when the relevant property regime does apply. Now, you will see that there are only 7 years between these two ages, and therefore there can't be a 10-yearly charge. There is, however, an exit charge when money is appointed out of the trust or the trust is wound up. Now, because there's only 7 of the 10 years, we prorata that maximum 6% tax charge. So it is a maximum of 4.2% if money is paid out at 25. Again, this can only be done by parents, so can't be set up by grandparents. The third option is called an immediate post-death interest, so we call it an IPDI trust. The relevant property regime does not apply at all to this trust, and the reason for that is that your children are deemed to own all of the assets within the trust. While saying that, they don't actually have access to the capital, so the children have a right to the income as it arises in the trust, and the capital can be distributed at the discretion of the trustees at whatever age they think it is appropriate. So this is an extremely flexible trust without the relevant property regime applying. I will just touch on the discretionary trust because although it does fall within the relevant property regime, it is still an option. So if money is placed into a discretionary trust over £325,000 and is left in there for more than 2 years after death, then it will fall within the relevant property regime and we will have those 10 yearly and exit charges on it. However, after death, there is a 2-year period, a grace period, where if the trust is wound up or if the monies in the trust are reduced to below £325,000, it will not fall within the relevant property regime and it will not attract those inheritance tax charges. So it is still an option for children. All of the trusts have their pros and cons, so it really is important that you take advice and use a professional when deciding how to leave monies to your children in your will.
Superb. Thank you ever so much. Alex, you mentioned IPDI trusts, which brings me on nicely to what we will be discussing next week, which is commonly known as the Life Interest Trust for married couples. Hope you can all make it. See you soon. Take care.